of the Legislative Services Agency in 2001 and 2011. And without further ado, let me introduce Ed Cook. Welcome.
Thank you. I would like to thank Drake Law School and the League of Women Voters for giving me the opportunity to talk about Iowa's very unique redistricting process. Which, when many people think of redistricting, they think of the term gerrymandering and not in a positive light. And here is a political cartoon from 1812 that spawned the phrase, created by combining the name of the governor of Massachusetts, Elbridge Gerry, with the term salamander. Iowa, however, does redistricting in a very different way. But before discussing how Iowa conducts redistricting, it's important to understand certain fundamental legal principles that govern redistricting in all jurisdictions. And most of these key principles were largely established in the 1960s. First, in a series of cases, the United States Supreme Court established the one person, one vote requirement as it relates to redistricting. Baker versus Carr in 1962 established the notion that the legislative apportionment was a justiciable issue and merited judicial evaluation. Subsequent decisions applied the equal population requirement, one person, one vote, to both congressional and state legislative districts. For congressional districts, early on, the standard was strict equality. The districts needed to be as nearly equal as practicable. In addition to the one person, one vote requirements, the Voting Rights Act of 1965 has implications on election law and redistricting. Section 5, which is never applied to Iowa, required Justice Department pre-clearance prior to making certain election law redistricting related changes in selected coverage jurisdictions. However, in 2013, that formula was declared to be unconstitutional in Shelby County versus Holder. Section 2 applies to all jurisdictions and prohibits imposing or applying practices or procedures to deny or abridge the right to vote on account of race or color, or because a person is a member of a language minority. However, Voting Rights Act has never been a particular issue in Iowa. And that's based upon the key case, Thornburg versus Jingles, which established a three-part test for potential Section 2 violations. And the first part of that test is, can you create a majority minority district? And Iowa does not have the population sufficient or large enough or compact enough whereby a majority minority district could be created. What about population equality? The United States Supreme Court has rendered several decisions establishing this requirement. And the key is how equal and by what standard should districts be equal. Important to note, really before discussing population equality, is several terms. There are really two key percentages. When people refer to deviation percentages, it generally refers to two calculations. One, which is defined here, is the mean deviation percentage variance. What you do is you take the population of the districts in a plan and compare it to the ideal population for those districts and express that as a percentage. The ideal population is determined by taking the total population of a state and dividing it by the number of districts that you're trying to create. And it gives you an ideal population. The other population equality standard that is generally referred to as here is the overall range percentage variance. And what that is you take the range of a plan, which is the difference between the most populous and least populous district, and then divide it by the ideal population for a district and express that as a percentage. Most cases, when they talk about deviation percentage, are referring to the overall range percentage variance, although the other calculation is important as well, especially in Iowa law. The key case in establishing kind of the population equality standard for congressional districts is Karcher versus Daggett. And that case held that an overall range percentage percentage of 0.69% was unconstitutional. Court noted that reaffirmed that there are no de minimis population variations which could practically be avoided, which nonetheless meet the standard of Article 1, Section 2 without justification. Court did, however, note that certain variations can be justified, and they noted that any number of consistently applied policies might justify some variance, including, for instance, making districts compact, respecting municipal boundaries, preserving the cores of prior districts, and avoiding contests between incumbent representatives. Court further noted, and I think it's important, is that the showing required to justify population deviations is flexible, depending on the size of the deviations, the importance of the interests, and the consistency with which the plan reflects those interests, and highlighted here, and the availability of alternatives that might substantially vindicate those interests yet approximate population equality more closely. It's somewhat of a comparative test. And so if you have plans that still meet all these state interests that has a better population equality, the court is indicating that that is probably the plan that should be adopted. Subsequent to that case, after redistricting, after the census in 2011, West Virginia did congressional redistricting, and a challenge was made. In that case, the Supreme Court held that an overall range percentage of 0.79% was constitutional. In that case, the court determined that the deviation was justified based on valid, consistently applied identifiable state objectives, one of which was not splitting counties, avoiding contests between incumbents, and minimizing population shifts between districts. The court noted that no alternative plan presented to the court with better population deviations met all of those objectives. Therefore, they determined that the plan adopted by West Virginia was constitutional. In conclusion, for congressional redistricting, the population equality standard is generally to get each district deviation from the ideal as close to zero as possible. There's no safe harbor deviation percentage. The standard is to get the districts as nearly equal as practicable. Of course, it is a case-by-case analysis to determine if any population variation is specifically justified. The deviation must be based on consistently applied and identifiable state objectives, and the court's going to examine whether alternative plans that meet the state's objectives with better population deviations are available. State legislative districts has a less stringent federal constitutional requirement. The case law generally is determined that if a state or local legislative map with an overall range percentage of less than 10% presumptively complies with the one person, one vote rule. It's not absolute, but the strict equality standard of congressional redistricting has not been applied, at least from a federal constitutional perspective, to those jurisdictions that deal with state legislative districts. But what about Iowa? This presentation, of course, is talking about Iowa's process. There are really three key events that really shape Iowa's current redistricting process. First occurred in 1968 when Iowa's constitution was amended, largely as a result of the Supreme Court decisions subsequent to Baker versus Carr. In 1972, the Iowa Supreme Court held that a legislatively enacted plan was invalid based on population exactness and prohibited factors. And so the case law and revolving around that decision is important in understanding Iowa's process. Ultimately, in 1980, Iowa's current redistricting process was enacted in legislation that then applied for redistricting cycles beginning in 1981. So what about the Iowa Constitution? What happened in 1968? There were several amendments to Article 3 of the Constitution. Article 3, Section 6 here was amended to provide that not more than 1/2 the membership of the House of Representatives, that the number of senators should be not more than 1/2 the membership of the House. And they should be classified so that as nearly as possible, 1/2 of the members of the Senate shall be elected every 2 years. The idea being that senators should be able to serve a 4-year term. Article 3, Section 34 established fairly stringent requirements in regards to redistricting at the legislative level, provided that the Senate should not consist of more than 50 members and the House not more than 100 members. And each district created shall be of compact and contiguous territory. that senatorial and representative districts shall be apportioned on the basis of population. It did provide that the General Assembly may provide for additional factors which may be considered in apportioning of senatorial districts, and also established a fairly modest population equality standard for Senate districts. In regards to congressional redistricting, Article 3, Section 37 was amended to provide that when a congressional district is composed of 2 or more counties, it shall not be entirely separated by a county belonging to another district. In effect, congressional districts need to be contiguous, and further provided that no county shall be divided in forming a congressional district. Redistricting for congressional districts, it consists of whole counties. Also important for 2 additional changes made in 1968, one of which Article 3, Section 35, which is going to be implicated probably this year, provided that the General Assembly shall complete the apportionment of senatorial and representative districts prior to September 1. But if that apportionment fails to become law prior to September 15th, the Supreme Court shall cause the state to be apportioned in the senatorial and representative districts prior to December 31st of such year. And in doing so, reapportioning authority shall be able to shorten the term of any senator prior to completion of the term. For all redistricting plans, Article 3, Section 36 provides for review by the Supreme Court and states that upon verified application by any qualified elector, in effect, any eligible voter in the state, the Supreme Court shall review an apportionment plan adopted by the General Assembly. And if they find that the plan does not comply with the requirements of the Constitution, the court shall adopt or cause to adopt a compliant apportionment plan. That provision further provides that the Supreme Court has original jurisdiction of all litigation questioning the apportionment of the General Assembly or any apportionment plan adopted by the General Assembly. Subsequent to these constitutional amendments and in preparation for the General Assembly that was going to be held in 1971 and 72, new redistricting plan needed to be adopted. And so in 1969, the Iowa General Assembly established a new redistricting plan for legislative districts for use in just that one General Assembly. The process utilized a 14-member commission appointed by the state party chairs. There were 2 members per each congressional district. Obviously, at that time, Iowa had 7 congressional districts. To be based on the 1960 census, would consist of 100 state representatives and 50 state senators, should follow counties whenever possible, and did provide that the General Assembly, after they got a plan from the commission, could modify it or adopt its own plan. As a result, the Iowa General Assembly passed its redistricting plan. And see here, the overall range percentage variances for that plan for the Senate was 12% and the House was 14%. Following enactment of that plan, that plan was challenged in court, and pursuant to the Constitution, the Iowa Supreme Court had original jurisdiction of considering that challenge. And the Iowa Supreme Court did find that the population variances did exceed those that were constitutionally permissible. They found that reasons of protecting incumbents and limiting contests with existing members were insufficient reasons for justify those population variations. They utilized that very exacting congressional equality standard. The court did decide on a split decision that time constraints prevented the adoption of a constitutionally valid plan for the 1970 elections, and therefore allowed the plan to be used for just that General Assembly. The court did, however, direct the legislature in 1971 to adopt an acceptable plan for the next decade. Of course, in 1971, following the 1970 census, the Iowa General Assembly, using the more traditional approach to redistricting, adopted its own legislative redistricting plan. And here, the overall percentage variances for that plan were for the Senate 3.2% and for the House 3.8%. The plan was challenged before the Iowa Supreme Court, filed by 3 different applications, one of which was from the League of Women Voters. And the Iowa Supreme Court declared that the legislatively enacted plan was unconstitutional for both population and compactness grounds. They rejected establishing a de minimis population variance standard for districts, there isn't any particular percentage that the court found was sufficient to justify variations. And they noted several impermissible considerations that you could not use to justify population variances, such as protecting incumbents, preserving present districts, avoiding joining part of a rural county with an urban county, avoiding election contests, and ensuring the passage of the redistricting plan. Following a determination that the plan was invalid, the court retained jurisdiction and drew its own plan, utilizing the expertise of the Legislative Service Bureau, the predecessor agency for the agency I'm now a part of, to assist in drawing the plan. And as you can see, the overall range percentage variances were quite low. For the Senate, it was 0.05%, and the House was 0.09%. One thing the court did do was provide that all Senate districts were to have an election in 1972. And the court by law determined which one of those Senate districts would have an election for a 2-year or for a 4-year term. Following the court's adoption of the plan for the 1970s, and I find this quote interesting, the Chief Justice of the Supreme Court at that time was asked and was quoted in the Des Moines Register on what advice he would give to others on how to apportion the state. The Chief Justice, C. Edwin Moore, stated, "First, I would say to get the help of experts, then check the population very carefully, using the latest figures you can get. Computerize everything to the last detail. And finally, don't get into a discussion about where somebody lives or if a district is a Republican or Democratic stronghold. That gets you off the straight and narrow. The purpose is to ensure that every citizen, whether he lives in the open country or in the city thick with people, gets an equal vote. That's what it's all about." And so what happened prior to the round of redistrict of the census in 1981, Iowa adopted Iowa's current redistricting process, established in Iowa Code Chapter 42. The remainder of this presentation is to discuss how Iowa's process works. There are really two key elements to Iowa's redistricting process. There are redistricting standards, and of course, the process itself. How does redistricting get done? The redistricting standards consist of both absolute and relative standards. It's hierarchical in structure. The standards are generally described in order of precedence, the most important listed first. And objective measurements are used for a lot of the relative standards. So what are the specific redistricting standards? They are codified in Iowa Code Section 42.4, and they're generally applicable to all levels of redistricting in Iowa. Of course, the first and most important is population. The Iowa Code provides for congressional districts that they should be as nearly equal as practicable. That no district shall vary by more than 1% from the ideal population for congressional districts, except as necessary to comply with the whole county constitutional provision. And the burden is on the General Assembly to justify any district with a variation in excess of 1% from the ideal population. Of course, in practice, the Legislative Services Agency utilizes that a very exacting congressional standard established by the United States Supreme Court. So we try to get the population deviations of each district as close to zero as possible, consistent with Iowa Constitution's whole county provision. Relying on any set percentage is unwise. There's no safe harbor percentage under the United States Constitution and applicable case law at the Supreme Court level. And case law does support the requirement that each successive congressional plan presented have an equal or lower population variance. And population requirements also apply to legislative districts. And again, the Iowa Code provides that legislative districts should be as nearly equal as practicable. Provides that the mean deviation percentage shall not exceed 1%. The overall range percentage for a plan should not exceed 5%. But it places the burden on the General Assembly to justify any district with a variation in excess of 1% from the ideal population. In practice, the Legislative Services Agency uses the strictest requirement. No district shall vary from the ideal population by more than 1%. This prevents shifting the burden to the General Assembly to justify wider population variances And it is consistent with the 1972 Iowa Supreme Court case, which utilized a very exacting population standard in examining state legislative districts. The next requirement is respect for political subdivisions. It provides that to the extent consistent with population requirements, district boundaries should coincide with boundaries for political subdivisions. The number of counties and cities divided should be as small as possible, and provides that you split the largest political subdivision or the smaller, unless a legislative district line follows a county line and splits a city. In practice, of course, for congressional redistricting, the Iowa Constitution controls provides that no county lines will be split in creating congressional districts. For legislative districts, we follow the statutory requirement. And if a political subdivision is to be split, we try to keep the number of splits to a minimum. The next requirement under Iowa law is contiguity. And Iowa code provides that districts shall be composed of convenient contiguous territory. No point contiguity is allowed and graphically presented here, so that if districts only are connected at a point, that district is not considered to be contiguous. This is an absolute requirement. It is constitutionally required for both congressional and legislative districts. The next requirement is compactness. The requirement is that districts shall be reasonably compact in form, consistent with the other standards previously discussed. Provides that compact districts are square, rectangular, or hexagonal in shape and should not be irregularly shaped. And there are two compactness measurements provided by Iowa law to kind of examine compactness. Important to note that compactness is specifically required by the Constitution for legislative districts. So what are those two compactness measurements were established by the Iowa Code? The first one is length with compactness. Provides that the compactness of a district is greatest when the length of the districts and the width of the district are equal. In effect, this is examining the squareness of districts. The more square a district is, the better length with compactness you will find. The other standard is perimeter compactness. The code provides that the compactness of a district is greatest when the distance needed to traverse the perimeter boundary of a district is as short as possible. What perimeter compactness is trying to establish is, are these districts irregularly shaped? In effect, the commonly known notion, do they look like they're gerrymandered? And so if you have very smooth edges that are not jagged, those district would have a lower perimeter compactness score, which would be what's preferred. Graphically, this is what the compactness tests are examining for both the length, width, and perimeter compactness. Finally, Iowa Code also establishes certain prohibited factors. Provides that no district shall be drawn for the purpose of favoring a political party, incumbent legislator, or member of Congress. The code provides that the address that in drawing respective boundaries, you can't use the addresses of incumbent legislators or members of Congress, political affiliations of registered voters, previous election results, any other demographic information other than population head counts, except as required by the Constitution and the laws of the United States. As you can see, these standards track pretty closely to what the Iowa Supreme Court held in 1972, establishing what was important and establishing what can't be used to justify unequal population districts. Another requirement in Iowa law is nesting. Iowa law provides that each state representative district shall be wholly included within a single senatorial district. So for those familiar with Iowa House District 1 and 2 comprises Senate District 1, and it goes all that way. And so no Senate districts cross a state representative boundary. Iowa law also provides that so far as possible, each representative in each senatorial district shall be included within a single congressional district. Obviously, with Iowa having only 4 congressional districts, that's possible for legislative House districts. All 100 House districts does fit within each of the 4 congressional districts, but 2 Senate districts do cross a congressional district boundary. But we kept the number of times we had to do that to a minimum based on Iowa law. One final thing, which is not a line drawing requirement per se, is Iowa Code does provide for the mechanism of dealing about for Senate elections. As noted in the Constitution, one of the requirements is that you should try and classify Senate districts so far as possible, so that half the Senate is only up every 2 years. And so the Iowa law provides that each bill embodying a plan drawn under this section shall include provisions for election of senators to the General Assembly, which would take effect in the years ending in 3 and 5. So in practice, Article 3, Section 6 provides that Senate districts shall be classified to keep the number of Senate elections for a 2-year term in the year ending in 2 to a minimum. And Iowa law establishes a procedure for determining whether senators elected in a year ending in 0, in this case 2020, can hold over and serve a 4-year term. And so LSA numbers Senate districts in a plan to try and limit the number of elections in 2022 for a 2-year term by numbering new Senate districts that contain the address of a senator elected in 2020 with an even number, creating potential holdover senatorial districts. Keep in mind, however, that we do not number Senate districts until the district boundaries for the proposed plan has been established. Political considerations are certainly not allowed in drawing of proposed districts. Well, those are the standards under Iowa law. What's Iowa's redistricting process? There are 2 key players in regards to Iowa's process. First, the Legislative Services Agency, of which I'm a part, and the Temporary Redistricting Advisory Commission, commonly referred to as the TRAC. The Temporary Redistricting Advisory Commission is established by code. It consists of 5 members. And those membership should be established no later than February 15th, 2021. It consists of 4 members appointed by the majority and minority leaders of the General Assembly. And those 4 members shall select the 5th member and chairperson of the commission. This round of the redistricting, our 4 members have been appointed, but has yet been able to select the 5th member for the commission. There are certain requirements to be a member on the commission. They have to be an eligible elector of the state. However, it cannot hold any partisan office or political party office, and cannot be an employee or relative of the member of a General Assembly or Congress. Important, however, is to note the duties of this commission. And the key, of course, is to refer to the term advisory. Unlike commissions that may be established in other states, the duties of the Temporary Redistricting Advisory Commission, Iowa, are somewhat limited. The 2 key ones are they can provide advice and guidance to the Legislative Services Agency on certain redistricting matters upon written request to the Legislative Services Agency. And they are to conduct at least 3 public hearings and submit a report to the General Assembly on the first proposed redistricting plan. TRAC, however, does not have any access to redistricting plans prior to delivery of the first plan. They do not have approval authority over any proposed plan. They do not have authority to direct the Legislative Services Agency regarding requirements for the development of plans, except upon our written request. They're pretty clearly an advisory commission. Legislative Services Agency, of which I am part, is created as a nonpartisan central legislative staff agency under the direction and control of the Legislative Council. Our duties primarily, and from my division, the Legal Services Division, is to provide drafting and staffing services for the legislature in a nonpartisan manner. And so we staff both. So we provide drafting assistance for both parties, regardless of their party, and staff all those committees. But we also have a statutory role in congressional, legislative, and local redistricting. Our duties in regards to redistricting is that we are solely responsible for preparing each proposed redistricting plan. There's no interaction or involvement with the TRAC except upon written request. Legislators or any outside interests while plans are developed and selected. So how does redistricting in Iowa get started? First, of course, is federal redistricting efforts. Key first date, of course, is Census Day in 2020. That's required by the Iowa Constitution and is April 1st, 2020. Subsequent to that is congressional apportionment. It's required by the United States Constitution, and United States Code requires that the resident population totals for the state should be delivered to the president by December 31st, 2020. And following that, the apportionment totals would be delivered to Congress. What happens is once the population is determined, the number of members of Congress each state is entitled is determined based on the population of the state. As you can tell, however, that December 31, 2020 deadline has been passed. And so far, that information is yet to be delivered to the president for delivery to Congress. And we'll discuss a little bit about that later on in the presentation. But that's a requirement under the United States Code. Next requirement is the Census Redistricting Data Program, Public Law 94-171, which directs the United States Census Bureau to make special preparations to provide redistricting data needed by the 50 states. And they're required to provide this redistricting data within 1 year following Census Day, or April 1st, 2021. However, as you probably note, that deadline will not be met this year. And so I'll discuss a little bit about kind of the issues involved in regards to that particular delay. Well, that information does provide the data necessary for states to conduct redistricting. And so based on these federal redistricting efforts, how does Iowa do redistricting? And that delivery of that data by the Census Bureau triggers the start of redistricting in Iowa. And the Iowa Code requires that the Legislative Services Agency use that data to assign a population figure to each geographic or political unit used for redistricting, and to then begin the preparation of congressional and legislative districting plans. So what's the requirements in regards to our preparation of proposed congressional and legislative redistricting plans? We are responsible for submitting up to 3 plans for consideration by the General Assembly. All bills are submitted by the Legislative Services Agency in bill form. It's subject to enactment through the legislative process. And all plans include both a congressional and a legislative redistricting plan. Iowa law requires that the plans include both congressional and legislative redistricting plan, and the qualified nesting requirement talked about in the standards necessitates simultaneous submission and consideration. If you're going to have legislative districts followed to the extent possible congressional districts, you need to create them at the same time. The duties of the Legislative Services Agency upon delivery of the bill is also established by Iowa law. We're required to provide to the public copies of the bill, maps illustrating the plan, and a summary of standards for development of the plan, to include population of totals and the relative deviation from the ideal population of each district created in the plan, so population statistics. So what happens upon delivery of the census data? So the first plan is required to be delivered to the General Assembly no later than 45 days after the release of that data. And the consideration of that bill is subject to certain requirements. Prior to the General Assembly considering the bill, the Temporary District Advisory Commission is required to conduct at least 3 public hearings and to issue a report to the legislature. The legislature may not consider the bill until at least 3 days after that report has been released. The bill must be brought to a vote expeditiously and shall continue through the process until rejected by a vote of the entire House or the Senate or by veto of the governor. The bill must at least get to the floor of the House or Senate. It cannot be defeated in committee. And for the first plan, only corrective amendments are allowed. If the first plan is rejected, the second plan is required to be delivered within 35 days after the first plan is rejected. It will be prepared by the Legislative Services Agency in accordance with any reasons for rejection of the first plan. And the House or Senate can provide by resolution for reasons why the first plan was rejected. Or the governor by veto message can also provide reasons. Keep in mind that those reasons cannot conflict with Iowa Code and constitutional standards. And the second plan, once delivered, is also subject to certain requirements. The legislature may not consider the bill until at least 7 days after delivery of the bill by the Legislative Services Agency. And like the first plan, it must be brought to a vote expeditiously and continue through the process until rejected. And only corrective amendments are allowed. The legislature cannot reconsider the rejected first plan. They have to either vote the second plan up or down. Again, if the second plan is rejected, the third plan is required to be delivered by the Services Agency within 35 days after that plan is disapproved. Again, like the second plan, it can be prepared in accordance with reasons for rejection of that second plan, so long as they do not conflict with code standards. And like the second plan, it may not be considered until at least 7 days after delivery of the bill by the Legislative Services Agency. However, unlike plans 1 and 2, their third plan is subject to amendment in the same manner as other bills. So what are some considerations in regards to review and consideration of prospective plans submitted by the Legislative Services Agency? Of course, the key requirement is population. And the Legislative Services Agency provides that each successive congressional plan will be of equal or better population variance than the plan that was rejected. It will not be worse. Also important to note is the options. What are potential options? Each plan released by the Legislative Services Agency is considered to be the plan that best meets the criteria at the time of release. And there's no requirement that a successor plan be different. The Legislative Services Agency does not create like 3 plans and hold back better plans for consideration as plans 2 and 3. We provide the best plan we can for each round of redistricting. So don't assume that a better congressional or legislative plan may exist. Finally, keep in mind that the standards apply to all the plans. There are no new standards that you go from plan 1 to plan 2 or plan 3 in regards to how we prepare the prospective plans. The legislature or governor cannot create new standards beyond those required by the Constitution and statute through the resolution or veto message rejecting the plan. They can provide a reason for that rejection, but they need to still be consistent with the standards that apply to all plans. Important to note is that 1972 Iowa Supreme Court case severely limited acceptable non-population redistricting standards. As noted before, there are deadlines in regards to completion of at least legislative redistricting. And although this slide is titled legislative inaction, this year it probably could be entitled legislative impossibility. Could potentially be judicial intervention. As noted for the General Assembly, the Iowa Constitution establishes a deadline of September 1 for the General Assembly to complete legislative redistricting. And if that has to be completed enacted by September 15th. Otherwise, the Iowa Supreme Court shall cause a redistricting plan for the General Assembly to be established. Congressional redistricting, however, does not have a constitutional deadline. In all cases, however, whatever plan that is enacted by the legislature is subject to review by the Iowa Supreme Court. And Article 3, Section 36, as noted before, provides the Supreme Court with original jurisdiction to review an enacted congressional plan and to provide that if the plan is challenged and struck down, as what happened in 1972, the Supreme Court has 90 days to adopt a valid apportionment plan. So once congressional and legislative redistricting is completed, redistricting, at least from a statewide perspective, is not complete. Local redistricting also has to occur. In this case, the Secretary of State is primarily responsible for overseeing this duty. However, the Legislative Services Agency is now statutorily required to help develop proposed Plan 3 county supervisor districting plans. What are Plan 3 counties? Those are counties that elect their county supervisors by districts. And so if those counties elect their supervisors by districts, once they've completed a precincting plan, the Legislative Services Agency, similar to what's done for congressional and legislative redistricting, will come up with a proposed county supervisor plan. Also, the election of senators in 2022 is a post-redistricting effect. How are 2022 Senate elections handled? Keep in mind that Senate elections are dependent on whether the district number for a Senate district is odd or even. Odd numbered districts had elections in 2018 and will have elections again in 2022. Even numbered districts will have elections in 2020 and in 2024. However, keep in mind that redistricting impacts a staggered election year cycle by occurring just 2 years after an election for half of the seats in the Senate, those even numbered districts, by inevitably changing the boundaries and numbering of senatorial districts. So how are elections handled in 2022? Iowa Constitution permits the shortening the term of any senator if necessary when establishing new senatorial districts. But Iowa law does not mandate an election in every senatorial district for the next general election cycle, even though that's what the Iowa Supreme Court did in 1972. Iowa law does provide that certain Senate incumbents shall be allowed to continue serving for a 4-year term without being subject to an election during the first general election following their districting. For odd-numbered districts, fairly simple. The Senate election will be required in 2022 for a 4-year term, and that's regardless of which incumbent senator may now be residing in that new odd-numbered district. No senator is entitled to a 6-year term. Even-numbered districts, which are designated as a holdover senator, will have an election in 2024 for a 4-year term. However, a Senate election may be required in 2022 for a shortened 2-year term. So which ones will not require an election? And the Iowa law generally establishes kind of the last senator standing rule. And so if only one incumbent senator who was not resigned as of third Wednesday in February 2022, and who was elected from an even-numbered district, was elected in 2020, is residing in a new even-numbered senatorial district, that incumbent senator can hold over and will not be subject to an election until 2024. There is, however, what's commonly referred to as a leapfrog rule. So an incumbent senator from an even-numbered district can't cross the state to a new even-numbered district, and if they were only the only incumbent in that district, be able to hold over for a full 4-year term. And so Iowa law establishes a lone leapfrog rule. That incumbent senator needs to be within the district that they were elected from and cannot now be in a new district that would not be across the state. So obviously an election would be required for a short 2-year term if those conditions are not met. There are no incumbents residing in that new holdover district, or if more than one incumbent senator resides in that district, an election will be required for a shortened 2-year term. So what's happened under Iowa's redistricting process? What's been the history? In each case, since Iowa's process has been established, the plan presented by the Legislative Services Agency has been adopted without amendment. In 1981, the legislature went to Plan 3 for adopting the plan as submitted by the Legislative Services Agency. In 1991, the first plan was adopted. In 2001, the second plan was adopted. And last time in 2011, the first plan was adopted. In each case, no enacted congressional legislative plan under this process has been challenged in court. And this slide here provides some population statistics for each congressional district plan adopted. As is apparent, in all cases, plans submitted by the Legislative Services Agency and approved by the General Assembly had minimal population deviations. Each plan having an overall percentage variance of less than 0.05%. Similarly, for legislative districts, since 1981, the deviations for Senate and House districts have been extremely low, all of them being within the 1% requirement, providing therefore that the overall range percentage variance for those plans were all under 2%. And this slide demonstrates the impact of drawing congressional and legislative district boundaries without regard to political considerations by showing the number of incumbents paired in each adopted plan. As you can see, in each cycle, members of Congress, the House, and the Senate have been paired in the plan adopted. So what can we expect here in 2021? Obviously, the key factor that's impacting redistricting this cycle is that the two key deadlines from the federal statutory level have been delayed. And so the congressional apportionment at this point, the Census Bureau has indicated, will be completed by April 30, 2021, 4 months after the required date. And on that date, the resident population totals for each state will be delivered to the president. The president will then report the census count for each state and the number of representatives to which each state is entitled. Similarly, the Census Bureau has indicated that the data necessary to do redistricting at the state level will be delivered by September 30, 2021. In both cases, the Census Bureau noted the key reason for these delays, of course, as anyone can suspect, is the COVID-19 pandemic and the delays that engendered by that pandemic during the collection of census data in 2020. But obviously, that's going to have a significant impact on redistricting in Iowa. So what do we think we know at this point? Population of the state has grown somewhat. The Census Bureau July 1, 2020 estimate pegged the population of the state about 3.1 million people. Using that as an example, you can tell the ideal district population approximately for Congress will be about 791,000, for the Senate 63,000, and for the House 31. However, the unprecedented delay in the release of the census data will significantly impact how and when redistricting at the state and local level will be conducted. Obviously, a delay from April 1st to September 30 is going to impact a lot of deadlines, especially those established by Iowa's Constitution in regards to completion of legislative redistricting. It will have a ripple effect for local jurisdictions in trying to complete their precincting and city, ward, and county supervisor district plans. Kind of in conclusion, what is Iowa's redistricting philosophy, at least in my opinion? It is a system designed to enact a redistricting plan in an efficient and timely manner without political gridlock and to prevent political gerrymandering. The goal is to enact a plan that is defensible in court. So each successive plan must be better, primarily from a population deviation perspective, especially as it relates to congressional districts. Finally, it is a blind system from a partisan perspective. The idea being is that not taking into account any political factors will result in a plan that's fair to all. It will be an acceptable redistricting plan. There are some factors I think helps make Iowa's process successful, at least from a perspective that I have. First, of course, is institutional acceptance. The Legislative Services Agency is viewed as fair and nonpartisan. And the General Assembly has been unwilling throughout the various redistricting cycles to risk an alternative approach, such as bypassing the Legislative Services Agency, amending a third plan, or accepting an Iowa Supreme Court imposed plan. Important to how Iowa's redistricting process works, in my opinion, is the use of objective criteria. The intent is to eliminate, to the extent possible, the concern that subjective political factors were used to draw plans. And you can see that obviously population is a very objective criteria, is measurable. Compactness as well can be measured, and the Iowa Code establishes measurement criteria for determining which plan is better from a compactness standard. In addition, respect for political subdivisions can also be measured. How many counties and cities are split in a plan? You can compare between one plan to the next. Using all those objective criteria limits the possibility that any particular subjective factors were used to draw the plans. Of course, using all those criteria limits the number of acceptable plans. Use of that objective criteria and larger geographic units limits the number of acceptable plans, especially noted for congressional redistricting, because there are only 99 counties in the state. And redistricting is going to be composed of moving those 99 counties in different ways in order to create acceptable congressional redistricting plans. Although the partisan considerations are limited, they are not entirely eliminated, because under Iowa's process, the plan submitted by the Legislative Services Agency must be enacted. It is not imposed by the Legislative Services Agency. So the General Assembly has that ability to determine whether or not to accept a particular plan. Another factor somewhat unique to Iowa, that we do not have any significant Federal Voting Rights Act issues. The minority populations in this state is neither sufficiently large or compact enough to create a majority-minority district, which could impact then require compliance with particular requirements relating to the Federal Voting Rights Act. Finally, for more information about Iowa's redistricting process, you can look on the Iowa General Assembly website. There's two links. One's about redistricting, which provides general information about Iowa's redistricting process. Another link, Iowa Redistricting, provides plan year specific. And you can see the plans and the reports from 1981, 91, 2001, and 2011 give you an idea of how redistricting occurred during each of those particular processes. So this concludes my presentation about Iowa's very unique redistricting process.
Well, Ed, thank you so much. And we do have a few questions if we have some time for them now, I think. Some of the questions that were asked, I think they were early on, and I think you sort of answered them as you gave your presentation. But here's one from Carly Hayden Foster. She'd like to know, what are the rules regarding redistricting for local city council or county board of supervisor districts? Do you have advice or resources for local redistricting processes?
So most of the standards that I listed that apply to congressional and legislative redistricting also applies to local redistricting. They have some additional requirements as well. They cannot create precincts that are greater than 3,500 people in population. And for county supervisor districts, they can't split cities more times than possible. Guidance in regards to local redistricting is generally provided by the Secretary of State's office. We have been in constant communication with them, obviously trying to navigate some of the concerns dealing with the delay in the census population. But the key entity in charge of redistricting it from the local perspective is the Secretary of State's office. And they should be providing a lot of information to locals as we go through the rest of the year in regards to how we do that.
Okay. Here's a question from Thomas Collins. What is an example of a hexagonal district?
Well, I don't know if I can give you one. The idea being, of course, is that they should look somewhat like squares. And so I guess a hexagonal is not exactly perfectly square or rectangular. Keep in mind is that those two requirements, the length width compactness measurement and the perimeter compactness, are the ones that we use. And so I think that was a term that was used when it was created way back when, and we certainly haven't changed it. But to give you an example of one that kind of fits that criteria, I don't know if I could tell you one.
All right. How about this question? What are corrective amendments? And could you give an example?
Sure. So what can happen is when you can look on Iowa Code Chapter 41, and you can look at a variety of streets describing all the 100 house districts. And so what can happen is that we may have, in creating the bill, misidentified a street, got something off. And so what would be to maybe change a street name, or the plan doesn't match up exactly with what's described in the bill. And so we need to make a correction to make sure it matches up with what what the actual plan provides. And so I think last time we may have had a typo or a particular issue with one provision. And so that's what a corrective amendment is. It's not changing district maps, lines, or anything along those lines. But you can find mistakes. You have a fairly lengthy bill that's describing a lot of streets in Cedar Rapids and Des Moines and Dubuque. There can be mistakes made. And so we try to avoid it. But if we find one as that bill is going through the process, we're going to make a correction.
Okay. All right. So Ed, do you have any reason to believe that the population count that will be provided by the Census Bureau will be less than fully accurate, whether for reasons related to the pandemic or to politics?
Well, what the Census Bureau has indicated, and part of the reason why they've indicated there's going to be this delay, is that their goal is to provide an accurate count to the extent possible. And so they can only use the information they've been provided. You can imagine that some of the delays that occurred last year is going to impact their ability to do that. Typically what happens is that after the census day, April 1st, they go into the field and try to fill in the gaps for those that didn't respond online. And they would do that through the end of July. Of course, it's all got to be tied back to April 1st. Well, they were they weren't able to get in the field for about 3 months. And so they put that off until the end of October. Well, then other things happened. You had hurricanes, you had the wildfires, you had a lot of other issues. And so, and also still dealing with a pandemic and trying to fill in those gaps. And so they obviously are going to do the best they can, given the resources they had, and they're trying to use as much information they can to try to match up the information they provided to make sure that the information, there are enumerators. And so they try to fill in the gaps using other records. So they may know someone lived in this house, weren't able to identify who exactly they are, but there may be other records that can fill in the gaps. And so they use all that time to try and do that. And so I think my sense for the Census Bureau is they're going to do the best they can to provide as accurate a count as possible.
Sure.
No count's going to be 100%, but they're going to try and do as best they can.
Right. And Ed, how many counties elect supervisors by district?
The last I checked, there were 38.
Okay.
And so for those particular counties, we will be involved in doing the county supervisor plans.
Okay. Now, can you give an example of a lawful or legitimate reason for legislature or governor to reject a plan?
Well, I mean, in 2001, typically, I mean, the legislature and the governor can reject a plan for any reason. I mean, there's no requirement that they have a good or bad. I mean, they can vote a plan down. In 2001, the plan was rejected for a variety of reasons, but the primary one for the congressional redistricting was that they felt like there were plans that could be of more equal in population. And so there's other standards, but they said it should be more equal in population. And we were able to identify a plan in 2001 that was more equal in population than the first plan that was rejected. And so that was absolutely consistent with the code requirements. It didn't have quite the compactness measurement that the first plan did, but it was more equal in population. And so that was a perfectly valid reason for rejecting the plan. But whatever reason they provide, I mean, they had some other reasons they didn't like the Western Iowa district or whatever, but that's not consistent with the code. And so we just found a plan that was better from a population perspective.
Okay. Here's a question. Can you share more about the challenges to electing a leader for the Redistricting Commission?
Well, obviously you have 4 appointed members, and then they've got to pick a 5th person that's acceptable to those appointed by the majority and minority party. And so that's generally, that's the limiting factor, that they've got to be able to come to an agreement as to an acceptable person to lead the commission.
Mhm.
One of the challenges this time is that we've held commission meetings from through Zoom. And so they haven't been able to meet in person. And so I think that kind of hurts as well, the ability for them to try and come up with a compromise candidate.
Are Iowa's prisons populations, STLL, counted in the county where the prison resides?
Prisoners are counted where they are.
Okay.
And the Census Bureau is still doing that.
Okay. And how many states follow a process that is similar to Iowa's?
Really, nobody does anything quite like Iowa. Several states use commissions and utilize standards that can be somewhat similar to the standards that Iowa has. The only other state, and they did this by initiative, that's going to utilize kind of the nonpartisan drafting agency for help in creating districts is Colorado. So we'll see how they do this time, but that's a recent provision. But no other state does it quite like how Iowa does.
Mhm.
It is unique.
Yes, it is the gold standard. And how does a member of the public contact members of the Temporary Redistricting Advisory Commission?
So obviously they have meetings, and the key really for the commission is when they hold public hearings. And so contacting the commission is generally a process of their role really is in regards to holding public hearings. And so there's going to be a myriad of ways for the public to comment on proposed plans. There'll be online approaches for doing that. We will certainly have that. And the commission will obviously hold public hearings as well. So that's primarily their role. I mean, it's to conduct public hearings and to hear from the public.
Okay. The counting of students in April 2020, when universities were closed effect on Story and Johnson County numbers. Are there any challenges anticipated because they were not there?
My understanding from the Census Bureau, and it's the Census Bureau issue, is that they are working with universities to try and ensure that those students on campus and off-campus housing are counted in that location, even though they may have gone to their parents' house or left because of COVID. And so they're trying to reassign them. That's another challenge that the Census Bureau is going to have, because some of those people may have been counted at their home location. And so the Census Bureau has to make sure that they're not counted twice, only counted once. And so my understanding is that they are trying to do that, but there's some additional challenges because of the fact that a lot of the students went home.
Sure. So do you suspect that Iowa will soon have to drop to only 3 congressional districts?
My sense of it is that it will be a while before that happens, but obviously it all depends on population. I mean, the mechanism for determining how many members of Congress a state has is called the method of equal proportions, which is confusing. Essentially what you do is you assign every state 1, and then you assign the 51st one, the 52nd, and then you all go all the way to 435. Based on all the estimates, we get our 4th member quite a ways from that 435 slot. And the 5th member is about an equal distance from kind of 435. And so we're kind of about in the middle. And so assuming the population doesn't take a drastic change in the next 10 years, it seems likely to me that in 10 years we will still have 4, but that's entirely up to the census count. But we're not close at this point to losing a district as we were in 2001. We had 5, but we got like the 430th
Okay.
seat.
Yeah.
Knowing that we were close to losing it, which of course we did lose.
Okay. Okay, so don't squiggly river-bounded districts seem to have high border to area ratios? Do you accommodate for this problem mathematically?
Well, the key, of course, is that there's going to be squiggly lines in regards to redistricting. But the key really for how we do redistricting is comparing it to another plan. So obviously, Missouri and whatever river is going to be the same in all plans. And so it's a comparison, it's a comparative process. And so the perimeter boundary is going to be whatever that perimeter is. And of course, there are some cities that don't exactly have straight edges either. But we're going to keep cities together. And so that's a higher standard than compactness. So you just kind of keep in mind that a lot of these standards are compared to what? So you have plan A and plan B, and you're comparing A and B with all those different criteria and using obviously the most important first. And so it's not really a problem that, yeah, there's going to be districts that are going to have oddly shaped lines because cities have oddly shaped boundaries.
Right.
We're going to compare that plan to another one that may keep that whole. We try to maximize each level of standard as we go and create standards.
According to the timeline, do we assume that the Supreme Court will make the decision this year?
Keep in mind that the deadline for the September 1 deadline applies only to legislative redistricting. So congressional redistricting is really not impacted per se by the delay. However, given the likelihood that the Census Bureau will not release data in time for us to have a plan prepared for the legislature to consider by September 1, Supreme Court is likely going to have to get involved and make a determination as to how redistricting will proceed. How that will happen is entirely a call of the Iowa Supreme Court. And so we don't exactly know what that's going to be, but at some point there'll have to be a determination as to how legislative redistricting will be done, because I certainly don't anticipate getting data sufficiently in advance of September 1 to allow for a plan to be potentially adopted by the General Assembly prior to September 1.
Ed, what is the potential of Iowa GOP's expressed interest in suing the U.S. Census Bureau to obtain the 2020 population data sooner than projected? Senate Majority Leader Whitfer made a statement along those lines on March 12th.
Well, 2 states have filed a lawsuit against the Census Bureau, Ohio and Alabama. in both cases requesting that the census data be delivered by the statutory deadline, or if not by then, as soon as possible afterwards. I know in Ohio, the Census Bureau filed a couple of statements by those involved with redistricting in regards to the impossibility for them to complete that task, obviously before March 31st, or even before the deadlines that they've established. And so we'll have to wait and see what happens with those two lawsuits. One thing that the Census Bureau indicated to the extent that anything may be moved up for one state would negatively impact other states and potentially impact other states in regards to delivery of redistricting data. So there are a couple of cases already in federal district court making that presentation. We'll just have to wait and see what happens.
This is a final question. I think maybe you've answered this, but the person asks that the deadline has passed now to elect a leader, correct? I think they must be talking about the temporary. Yeah.
Sure.
Yeah.
And, I mean, the deadline, ideally, in fact, the last two cycles that I was involved with, the chairperson wasn't determined by February 15th. That was shortly thereafter. But in both of those cases, we were in the process of receiving the census data. And so the need for the fifth person in commission chair was absolutely critical in those cycles. Ideally, we would have a commission member. We're having another meeting on Monday, and hopefully we'll elect the fifth person. But I mean, the requirement for the commission to conduct public hearings is unfortunately going to be a little ways off.
Yes, it is. Well, Ed, I think we've answered all of the questions. And I just want to thank you. What a great presentation. I've already seen also in the comments, people are commenting on what an informative, interesting presentation this was. And we're all very, very grateful for you for being here and sharing this with us. And so on behalf of the League of Women Voters of Iowa and the Drake Law School, I want to thank all of you participants for joining us today for this presentation. And thanks, Ed, and thank you all again for being here today.
Yes, thank you, Ed. That was very informative. And this event has been recorded, and so we will be sending that recording out if you would like to view it again. So thank you very much, everyone.